3, 2, 1, start. The facts of the case are that a complaint was submitted before the magistrate on 29th September, 2008 against the petitioners alleging that they had hunted and killed two female markhors and thus violated sections 8, 11, 13 and 19 of the Balochistan Wildlife Protection Act, 1974, the Act full stop. Subsequently, charge sheet challan dated 28th October, 2008 was submitted, wherein in its column number 6 with regard to the things taken into possession, it was mentioned that two hides/skins of markhors had been taken into possession. Full stop. The magistrate framed the charge on 21st February, 2009, and the petitioners pleaded not guilty. Full stop. The prosecution produced 5 witnesses, all of whom were serving in the Wildlife Department, respectively. Protection witness 1, 5, full stop. The petitioners recorded their statements under section of the Criminal Procedure Code (CRPC) but did not produce any defense witnesses. Full stop. The learned magistrate found the petitioners guilty and convicted each of them to a term of 6 months Criminal Revision number 114 of 2009 imprisonment and with a fine of 3,000 rupees each, and in default of payment of fine to undergo further simple imprisonment of 20 days. Full stop. Against the said conviction, criminal appeal number 7 oblique 2009 was preferred before the sessions judge, who wide order dated 25th April, 2009 reduced the sentence awarded to the petitioners to the one which they had undergone, which I am informed was 10 days, and reduced the fine to 1,000 rupees each, and in default whereof to undergo simple imprisonment of 20 days. Full stop. Learned counsel for the petitioners stated that the case against the petitioners is one of no evidence, there was no eyewitness of the incident, and the two markhor skins were not produced in court. Full stop. He further stated that neither any gun nor any empty cartridges were recovered. Full stop. The learned additional prosecutor general and the learned deputy prosecutor general stated that the revision was not maintainable as the petitioners before the appellate court did not contest their appeal on merits. Full stop, but simply sought a reduction in the sentences awarded to them, and the learned session judge accepted their plea and reduced the sentence of imprisonment to the one already undergone. Full stop. It was further stated that no reason was given why the sentence was reduced. Full stop. The maximum sentence that could have been awarded was an imprisonment of 2 years, and the magistrate had already taken a lenient view by sentencing the petitioners to only 6 months imprisonment. Full stop. Regarding the reduction in the imposition of fine, the same was not contested as the fine prescribed in section 19 of the act, in respect of an offence under section 8 for which the petitioners were convicted, was, imprisonment which may extend to 2 years, or with fine which may extend to 1,000 rupees, or with both. Full stop. It was lastly contended that under the circumstances the impugned judgment of the London magistrate to the extent of imprisonment may be restored, as the petitioners had admitted their guilt, by not contesting the appeal on merits, and they are now debarred to do so before the High Court in this criminal revision. Full stop and closed.